Hey, thanks for joining us again on another one Halloran and Sage interview series. With me today, I have Michael McPherson, a part of the Appellate practice group and a partner here in Halloran and Sage's Hartford office. Mike, thanks for joining us.
Thank you for having me.
Mike, let's just jump right into it. You're an appellate attorney. Tell us what that entails.
Sure. Well, as an appellate attorney, you get involved in a case sometimes before, it goes to trial to help trial counsel out and issue spotting, or I often get involved with what's called critical motions practice, where sometimes they'll, ask an appellate advocate who I would consider to be, professional writers. That's what we do. We do a lot of research and writing, and sometimes we're better suited to write dispositive motions or motions in limine and things like that help trial counsel with their trials. We also get involved to kind of take a 1,000-foot look at the case. Oftentimes when trial counsel are sort of embroiled in the trenches, they may not spot all the issues that are facing them, with the legal issues and how to preserve certain things and where to, preserve objections, and oftentimes to keep their case on track if they were to, lose at trial and wish to appeal, or even if they win, if there was something they lost, during the course of the case, whether it was a motion or something along the lines where, they want an alternate ground for affirmance, or they want a cross appeal. All of these things come up during the course of a trial, and they don't necessarily arise where you're going to want to be thinking about them afterwards. So as an appellate advocate, I get involved and can help trial counsel out. And, after trial, obviously, it's pretty straightforward, where once you've identified your issues, whether you're the appellant or the appellee, it involves basically, research and writing your briefs, and then the oral advocacy part, whether you're before the appellate court or the Connecticut Supreme Court, or if you're in the federal court system, before the Second Circuit Court of Appeals, which is where Connecticut is located, you'll handle those matters and shepherd it through the appellate process, and, working with trial counsel as well. After all, it is oftentimes their baby that you're taking, and they're very emotionally invested in it. And so that's sort of a general idea of what an appellate attorney does, or what I do as an appellate attorney here at Halloran and Sage.
Great, thanks. That brings me to my next question. What is the involvement, or the distinction rather, between an appellate attorney and a trial attorney, and where do they overlap?
Well, I think that if you're looking at a pure appellate attorney versus a pure trial lawyer, it involves a different skill set. I think that's an important distinction. One of the main differences that may seem obvious, but in terms of how it's approached, is not so obvious, is that trial lawyers are making an appeal to a jury. They're selling a story, a theme, and they're appealing to people's emotions. They're talking to lay people. They're not arguing issues of law. And so they're trying to convince a jury to rule or decide or find issues of fact in their favor. And so there's a lot more, I guess, theatricality involved, if you will, that works at that level. But at the appellate level, you're now dealing with, the legal issues, and it involves a different skill set, because you're no longer arguing to a jury. You are arguing to a panel of judges who are concerned with the law, who are not going to be swayed by, emotional or passionate arguments that proceed with at a jury level, and there's a lot finer details of the law. You've written your brief, you're now arguing it before them. And so it's, as an appellate advocate, your emphasis is on being a very persuasive writer, as well as being a very persuasive oral advocate, but in a different way than a trial attorney might do.
Yeah, dealing less with emotions and less with the facts of the case, but more with the law, the statutes at play, and the different things that might fly over the head of a juror.
Correct.